Well, welcome everybody to today's webinar, an update on the new General Insurance Code of Practice. My name is Shannon Delamotte and I will be your moderator for the session today. I'd like to lead with an acknowledgement to the traditional custodians on the land on which we work and live today, and recognise their continuing connection to the land, water and community. We pay our respects to their elders past, present and emerging, and we extend that respect to any Aboriginal and Torres Strait Islander people here today. A note to our audience that you have joined this webinar in listen-only mode. So this means that you'll be muted for the duration of the session, but I encourage you to submit questions throughout the session by using the questions pane, which is the question mark icon on your screen. The webinar will be recorded and a link will be emailed to you for viewing for a period of 2 business days. The recording will be available for paid members of AILA to view via the website library after AILA's 1-month embargo period. So I'd like to introduce our speakers for today's session. Our first speaker is Annabelle Butler. Annabelle is a financial services professional with more than 20 years experience, mainly in the public policy, consumer affairs, and financial resilience disciplines. As part of her ongoing roles, Annabelle is the industry chair of the General Insurance Code of Practice and an industry panel member for AFCA. Annabelle has served various roles, including the chair of the Australian Centre of Financial Services, Insurance Reference Group and board member, which provided policy advice to government, and a member of the Consumer Policy Research Centre, whose focus is on the use of data in creating good consumer policy and protections. Our second speaker is Paul Holmes. Paul is a principal lawyer in Civil Justice Service at Legal Aid Queensland. For the past 13 years, Paul's practice has focused on assisting Queenslanders in vulnerable circumstances with legal issues in all types of banking and debts and Australian consumer law disputes. Paul is a member of various committees, including the Australian Bankers Association, Consumer Outcomes Group, Insurance Council of Australia, Consumer Liaison Forum, African Consumer Liaison Group, and the QLS Competition and Consumer Law Committee. Our final speaker for the session is Rene van der Rijdt. Rene has been the Acting General Manager, Codes at AFCA, and Acting CEO of the Banking Code Compliance Committee since March 2021. In this role, Rene leads the strategic direction and operational management of the code team, ensuring delivery of its compliance and monitoring obligations for relevant industry associations and 5 independent code compliance committees across the banking, customer-owned banking, general insurance, life insurance, and insurance broking industries. Rene has worked in the code team since 2017, initially as the Code Compliance Investigations Manager and at AFCA and its predecessor scheme since 2011. So before I hand over the mic to Annabelle, we will have a Q&A session after the presentations, so please submit any questions that you have at any time throughout the session. Annabelle, I hand over to you.
Thank you very much, Annie. Good afternoon, everybody. I hope you can hear me. And I hope, well, I'm at home, of course, so let's hope the dog doesn't bark in the middle. And thank you for your kind introduction, Shannon. It's a great pleasure I've come to this afternoon. This is the second session I think we've run on the code in the last year or so. My colleague Paul was involved with the first one as well. So a couple of things I'd like to say about the code. Well, it's very exciting. It's underway. The 2020 code is now in full swing. And it had a staggered implementation process, principally driven by COVID, unfortunately, in recognition of some of the limitations that the industry was facing as a result of staff being impacted, etc., by COVID and having to work from home and changing the way they work. So last July, we kicked it off with the requirement to have family violence policies published online. And there's been a recent audit done of that, and I'll leave that to Rene to discuss that for the CGC. but also our colleagues in New South Wales and Legal Aid did some work as well on that, Paul. The wonderful Drew McRae ran that piece for the consumer advocates. And that was very helpful, thank you. No, not sure everyone was happy with the outcome, but it was a really good piece of work. So that's occurred back in January this year. Section 9, which is the customers who need extra support because they're vulnerable section, and Section 10, the financial hardship section, came into full being. And the reason we prioritised those two sections was because of COVID. We were concerned that we were going to start seeing more consumers in hardship and who would potentially be vulnerable. But also we understood that from a societal perspective more generally, they're probably some of the two key tenets of the code that really provide protections that reduce consumer harm, hopefully. That's the idea anyway. And then obviously first the sector, and we're in a very different environment now. The CGC has the ability to impose financial sanctions on insurers or signatories to the code if they commit significant breaches, and that's up to $100,000. So I just wanted to highlight that because it's unusual in Australia's sort of code environment, if you like, or ether that occurs. But that was done very deliberately by the sector. We wanted to really ensure that consumers and other stakeholders understood how seriously we actually take our code of practice in terms of compliance. So I'm not sure, Rene, if you've actually had to do that yet, but that ability now exists for CGC. In terms of what happens to that money, there's an organisation that's been employed through the Insurance Council Australia who will husband that money for us, and it'll be given out obviously as the coffers increase to organisations who apply in certain sectors for extra support. And as you can imagine, being insurance, there's a lot of it's around natural disasters, providing communities who are have suffered from a natural disaster and need that extra support immediately. So that's a really good piece of work, and it's obviously open to anyone, financial counsellors and legal aid included, Paul, if that's the case. So that's a really, really, really good piece of work. And I look forward to seeing how that works in practice, as we spent quite a lot of time sort of setting the whole thing up. So that's sort of the code today. I'm not going to sit here and harbour on about all the changes that were made. Hopefully people online understand those changes, but they were quite extensive. I think it's fair to say that we really concentrate on transparency. There's a lot more requirements on insurers to give extra information now to consumers, whether it's actually at the sales part of the process and renewals and those areas, or in the claims part of the process at the back end as well. And that was all done from feedback from consumer advocate groups and others who, through their work see that transparency is needed. So the code responded appropriately. I've already spoken about Section 9 and Section 10. The industry is very proud of Section 9, actually. It really has been a big shift in the sector to do that kind of work and provide that kind of support to consumers. And I say with great pride that everyone I'm aware of, at least, has taken it very, very seriously. So but bear with us, because it is an evolving thing as our knowledge and understanding increases and improves over time in what we can do to help people. So the next stage of the code, which is proving to be a pretty challenging piece of work, is enforceable code. So I'm sure most people are aware that this is part of the Omnibus bill that was put through as a response to Hayne late last year. There's a section in that bill that actually, well, I'll say requires and enables ASIC to choose sections of codes of practice to be enforceable under the Corporations Act. And so the general insurance industry's intention is to get authorization from ASIC for the code. And so we're starting on that journey. So we set up a small working group within side of the National Code Committee structure to look at this, and it's quite an extensive piece of work, so bear with us. It's all new, we've never done it before. So we basically have taken the ACTS tests. So the first thing we did is we've walked through the code line by line by line by line and worked out which parts of the code are actually reflective of other legislation. So, for example, the distribution sections in the code is pretty well a reflection of Corporations Act requirements and also the ASIC Act requirements. So an easy example is no pressure selling, but that's actually an ASIC Act requirement. It's been there for years. So we've removed those types of sections from this review as per the legislative intent. So obviously the privacy sections, that they're actually a reflection of the Privacy Act, so they've gone from this review, and we've just walked through the process. The changes with the legislation in regards to claims handling has meant that some of those sections that you may have once thought would have been in there have now been taken out because they fall under that regime into the future as a result of ASIC C12 requirements, which are the proof requirements that we had to provide for the licensing regime. And I must say, thank goodness the code has set us up very well to be able to answer those questions and prove to ASIC that we meet their views of, is efficient, honest and fair. So that was helpful. So we've done that piece of work, and then the next sort of tests are around whether the code provisions are broad in nature, and make sort of in principle commitments to the code, to the community, and there are some those types of concepts within the code. So they were pulled out as well. So an example of that would be the principles at the beginning of the code. They were never intended to be enforceable. They're written in a way that they're actually at a higher level to try and explain to consumers what the industry is trying to do and where it's coming from and what it expects of itself, rather than something that's sort of enforceable. Yes, you either do it or you don't do it type of thing. So they've been pulled out as well. There was a test about trivial code provisions, but we actually really struggled to find any. It was a bit of a strange test to try and put a lens over the code when you think, well, I don't think any of this isn't trivial. It's trivial. So that was a strange thing to do. So we're in the process of, we've basically now identified potential clauses we think will be enforceable, and we'll do some more refinements on those as well as we go along this journey. We are working with ASIC because obviously no one's ever done this before, and we will be working with the CGC and other bodies as we move through this, and we're actually going to hopefully working with the rest of the sector as well, because it's not just about the general insurance code, this is about codes generally, and there's sort of 5 codes I think that will fall under this process. So we're waiting for the RG183 update from ASIC. I know that they're looking at it at the moment, and we're hoping that we'll work with them on that very closely, because as I said, this is new. We're creating the rules as we go, and the intention is that hopefully the code will be put up for authorization either very late this year or early next year, and we'll go through that process with ASIC, and then obviously what is enforceable will be communicated through the official mechanisms. From memory, with the Act, ASIC has to create a legislative instrument to do so. That's how that sort of part works at the end. There will be some changes probably made as a result of that, just to let you know. Some of the clauses we've identified that should be enforceable probably aren't written in a way that they can be legally enforceable. So they'll have the language will have to be tightened up to make sure that it's actually enforceable through the Corporations Act as well, and that was actually another test that's actually in the law as well. That's probably all from me. I've done my 10 minutes, so I'll hand back to you, Shannon.
We're actually going to go straight on with me, Annabelle, so it's all good. No trouble at all. So thank you again, everybody, for attending. To give you a little bit of background about where I fit into the scheme of things, and this is Legal Aid does a lot of insurance work when it comes to following natural disasters. And unfortunately, Queensland has a lot of experience responding to natural disasters, as I'm sure people on the call have experienced. And we also do a lot of work. We get a lot of inquiries following motor vehicle accidents, both from the people affected or hit by the driver responsible, and also from responsible drivers who are either insured or not insured. So we see pretty much the full gamut of your major general insurance policies at Legal Aid. And my experience of the code and previous codes is that, as a general rule, most both consumers and people on the insurance side are trying to do the right thing. When things are going wrong, it's not as a result of usually any deliberate actions on the part of either the insurance staff or the consumer. And I think that's a worthwhile starting premise for when we start talking about the code, because the one thing I want all of you to keep in mind when it comes to dealing with the code and enacting the various documents under the code that have come in is the human needs to be at the centre. And the human at the centre of this, just to remind you, in Australia, the average reading age, last time I looked, is 12. And the average maths literacy age wouldn't be any higher than that either. And so I think it's really important when you're drafting the code documents that are in there for things like cash settlements, or drafting internal documents to allow you to help with vulnerable consumers, you've got to be really careful around the language. It's not an excuse for the lawyers on the call to get clever and wordy and include jargon, because that's not going to achieve the aim of the code. And what the test I would use is, if you're a claims staff writing a document for use by consumers, or you're a lawyer writing a document for use by a consumer, we can all get in the bubble and we'll give it to another lawyer, and another lawyer will understand the jargon, or we'll give it to another member of claims staff or somebody within your team looking at it. And we don't often see the jargon. When I'm doing something at Legal Aid, I will often give it to one of my litigation support staff who's not a lawyer and say, tell me what we want you to get out of this. And if it passes that test, that's usually a good sign that it's going to be understandable by the consumer. And so for me, that's the really important takeaway when you're drafting documents that this code has allowed, because I think there's a lot of really great stuff in there that's going to help consumers, and it builds on the previous codes. But we've got to make sure when we're doing those documents that a non-lawyer, a non-insurance person is going to get all of the good stuff we want them to get out of it. And so just be really careful about that. The other thing that I can say from the last 12 months that I think is a really important part of the code that we sometimes forget is we can get, and I do this, I work at Legal Aid, it's a bureaucracy. I can get caught up in the process. We all can. And I reckon in the last 12 months, the highest number of complaints I've got about insurance claims actually hasn't been about whether they've been paid or not. It's been about somebody from an insurer said, I will call you within 6 weeks to tell you where this is headed, or I will call you within 6 weeks to let you know when the repairer is coming to fix your roof. And 6 weeks will come and go, and there won't be a phone call. And that's usually the genesis of the complaint. And when it gets off to a start like that, it can often be hard to haul that claim back in. So my second takeaway in this space is be really careful to do what you say you're going to do. Consumers on the whole, and there are exceptions where we've all encountered, on the whole, consumers are pretty reasonable. And if, for example, yet another COVID lockdown means you can't get the repairer across the border between Queensland and New South Wales, or you can't get the specialist roof repairer to WA until 2024 because that's when the border might open again at the rate we're going. If you actually tell the consumer that, let them know what you're planning to do to get around that or to help that, they'll usually go with you. If they don't get any contact and they don't get any response, then they usually won't. And it's often really hard to stop those sort of ones ending up in AFCA. And those sort of ones shouldn't end up in AFCA because they're the really easy fixes of, we're going to call you within this period, you call them within this period, and if it's with bad news, tell them bad news and how you're going to fix it. Because not 100% of claims do not go 100% smoothly, but nearly all of them are able to be dealt with if you do that communication piece quickly and right. And so, although I don't think there's anywhere in the code that says communication is the centerpiece of the code, I actually think it is. And if you get the communication around all of these issues that are set out in the code, you're sort of 95% of the way there. Also a quick comment about the family violence policies. I don't see the family violence policies as any sort of competition. And I know Drew, who did what I think is a really good analysis of them, doesn't either. We both think, or what we both want, is now that report's done, if somebody else has done something good that you haven't done yet, steal it. There should be no competitive advantage around family and domestic violence policies in the insurance industry. If somebody's doing something good, adopt it, go with it, so that people who are in such vulnerable circumstances get the best possible assistance and help that they can. And I know the intent is there to give it. So if you can improve it by stealing somebody else's idea, go for it. And then just a little bugbear of mine to finish on. In terms of dealing with vulnerable clients following natural disasters, can we please fix how we interpret maintenance clauses and how we deny or not deny claims on maintenance clauses? Because I see too many claims that are denied where there's one line in an assessor's report which says words to the effect of, they may not have done maintenance properly. Guys, that's not enough to deny a claim. If somebody's got a hole in the roof and they haven't fixed it, or there's a wall missing, or they haven't fixed a window properly, or they've left a window open, that's exactly what that clause is there for. If all you can tell me is they may not have done maintenance properly, to be honest, that doesn't cut it. Similarly, if there's a nail missing from one corner of the roof and a 250 km/h cyclone's come through, that's not a reason to deny the claim either. Because that 250 km/h cyclone, unless you can show me that one nail made the difference between the roof staying on or not, I really struggle with why that would be a denied claim. So, and I'm happy to, if anybody wants to reach out to me to further that discussion, because it's a bugbear of all the consumer lawyers in this space, both at Legal Aid, Financial Rights, Consumer Action Law Centre. But on the whole, my experience is insurers so far are doing a good job with the new code, and long may that continue. Over to you, Rene.
Thanks, Paul, and thanks, Annabelle. And just quickly, as a segue, that comment that you made regarding either sharing or stealing good practice, in my capacity as the acting code general manager, I work across a number of codes, and in just slightly off topic, in banking, they've just released a report on direct debit cancellations, and one of the things that we're going to do there is actually facilitate a forum to share good practice, and all those subscribers of that code have actually quite eagerly embraced that. And we've also, in that report, positively identified, with consent, NAB as having a particularly good website on direct debit matters, and have actually said, have a look at this and adopt what you need. So I agree with you on that one. I will, just for the benefit of the audience, Annabelle, you noted that I think most of the people here would know about the history of the code and its implementation. I have got some speaking notes prepared, and I just did want to touch on, just for a couple of minutes, just on the committee, its role, and a little bit of the history, just for perhaps any lawyers present who work on behalf of subscribers. I'm quite sure the subscribers are all across it, but so if everyone would just indulge me a little bit, and I will be reading from some notes. So the Code Governance Committee, or the CGC, or the committee, as you'll hear it referred to within our discussions, is the independent body that monitors and enforces insurers' compliance with the code. The committee is responsible for identifying areas for improvement of insurance practices, and it also liaises with the Insurance Council of Australia and also reports to the ICA board on a quarterly basis. The code team, where I sit, at AFCA, supports the committee in carrying out its monitoring function. The team provides code monitoring, secretariat and administrative services to the committee, and is separately operated and funded, but is part of AFCA. The committee publishes an annual report containing aggregate data from industry and consolidated analysis on code compliance. As most of you are aware, the committee's monitoring activities include investigating compliance in areas of emerging risk, investigating reports from consumers and referrals from organisations such as AFCA, and also publishing reports and guidance notes to assist subscribers in complying with the code. As touched on by Annabelle earlier, and as all of you are aware, the committee has also got the power to impose sanctions on breaches or significant breaches of the code. The 2020 code has lifted obligations across subscribers, and also want to take the opportunity to remind subscribers and lawyers acting on their behalf that certain activities you carry out for subscribers as lawyers are going to be code captured. If I could just have the next slide, please. And the next one as well. Thank you. As you're aware, on the 1st of January 2020, the ICA published the 2020 code, and from that date, the 1st of Jan 2020 to the 30th of June of this year, code subscribers transitioned to the code in phases. Code subscribers have been required to comply with paragraph 95 of the code since the 1st of July, and that's the paragraph we've touched on earlier that requires code subscribers to have a publicly available policy to support individuals affected by family violence, including publication on websites. And that paragraph sits within Part 9. Code subscribers have been required to comply with the balance of Part 9 and the whole of Part 10, which deals with financial hardship, since the 1st of January this year. And prior to that, code subscribers were required to comply with the spirit and intent of both those parts between 1 July 2020 to the 31st of December of that year. And then, as you're aware, and that's why we're here, code subscribers have been required to comply with all other obligations from the 1st of July 2021 under a revised 2020 code, as it's an amended version of the 2020 code that was published on the 1st of Jan 2020. So today's topic is experience with the new code, implementation and operation. And for the committee, this means both monitoring compliance and providing guidance. As noted by both the previous speakers, the 2020 code has important obligations for subscribers on supporting consumers experiencing vulnerability and financial hardship. Part 9, the vulnerability part, applies to retail insurance only and is entirely new. Part 10 on financial hardship builds on the hardship provisions of the previous code and applies to both retail and wholesale insurance. Could I have the next slide, please? So, as noted, paragraph 95, the contains that requirement to have a publicly available policy on a website, and these provisions did not exist under the previous code. Paragraph 92 outlines that a person's vulnerability may be due to a range of factors, and I just want to list them because they're important, because then it's not just about age, it's also about, it could be age, it could be disability, mental health conditions, physical health conditions, family violence, language barriers, literacy barriers, which you've spoken to, Paul, cultural background, Aboriginal and Torres Strait Islander status, remote location, or financial stress. And the key requirements under Part 9 cover internal policies and training, support measures, identification, using interpreters, and mental health, and include the following. Paragraph 91 states that code subscribers must commit to taking extra care with customers experiencing vulnerability and recognise that each person's vulnerability is unique, creating unique needs which may change over time. And paragraph 96 states that code subscribers must have internal policies and training appropriate to employees' roles to help them identify vulnerability, decide on appropriate support, take account of particular needs or vulnerability, and engage with sensitivity, dignity, respect, and compassion. And paragraph 97 states that code subscribers will work with customers experiencing vulnerability to provide suitable, sensitive, and compassionate support as early as practicable. Could I have the next slide, please? Thank you. As paragraph 95 was introduced earlier, the committee has reviewed how subscribers are complying with this new obligation. It assessed, as we've touched on earlier today, it assessed the websites of relevant subscribers and their brands and found that overall, 99 out of 108 organisations, or 92% of organisations required to publish their family violence policies on their websites did so. The remaining 9 organisations did not have publicly available policies, either because the relevant organisation did not have a website or because it is part of a corporate group that had a group website. The committee worked with each of these organisations to ensure they published family violence policies on their websites, with the organisation not having a website creating one. Whilst there was a high level of compliance with the obligation, the review also looked at the ease of access to the policies, and the results were a little bit more mixed. Only a few of the websites had policies that were considered easy to find. 70% of subscribers fell into the meets the minimum standard category. And in total, as a result of the review, we recorded 1 significant breach and 7 individual breaches for not complying with paragraph 95. The outcomes of the review have been reported, and the website address is there on the slide. Could I have the next slide, please? So part 10, financial hardship, builds on the previous hardship obligations that were already in the 2014 code. And key requirements, and Paul, this comes to your part, but key requirements under part 10 include standards around communication with consumers, clarity on time frame to assess financial hardship applications, and training for employees and agents on the financial hardship requirements of the new code, including how to identify financial hardship. There are also now clear timeframes that apply to making a decision about a consumer's financial hardship application. Paragraph 116 states that code subscribers must advise consumers as early as possible if they require further information. 117 states that consumers have 21 calendar days to provide that additional information unless otherwise agreed. And paragraph 121 states that code subscribers must make a decision in writing about whether to provide hardship support within 21 calendar days of receiving an application unless further information is required. Could I have the next slide, please? The committee has been undertaking, as you're all aware, the code subscribers here particularly, a review to test subscribers' compliance with parts 9 and 10, and we do expect to publish a report before the end of the year. Early analysis suggests that there's been a very high level of compliance with these obligations, and we will continue to work with subscribers to remedy any breaches surrounding implementation. We expect that the committee will undertake a further review of compliance with the 2020 code now that the balance of the code is in effect. So we have done some analysis on this, and but we still need to take this to the committee for their final review, and we're still working on that. So I can't give any further insights at this stage, but to say, pleasingly, that there has been quite a high level of correct implementation. Could I have the next slide, please? So we did touch on sanctions. So Part 13, dealing with enforcement, sanctions and compliance, has also been a significant change in the new code with new provisions around the sanctions that the committee can apply. You'd all be aware of them, but some of the sanctions that can be applied are listed there, and it includes the payment of a community benefit payment for a significant breach up to a maximum of $100,000. The committee has recently consulted extensively on its operational guidance, setting out when the committee will look to apply a sanction and what it will take into consideration. On that, we've received extensive and detailed feedback from stakeholders, which is being incorporated, and the operational guidance is expected to be published shortly. And as I noted previously as well, Annabelle, we haven't as yet considered any significant breaches under the new code, particularly given the short time frame that it's been in operation. Could I have the next slide, please? So just the code and its application to lawyers, and I wanted to touch on this as well because I noted from the invite list that I saw that there are a number of legal firms represented here. So we've seen matters where a code subscriber has outsourced an individual complaint or the whole of its internal complaints handling function to external lawyers. Paragraph 158 and Part 11 complaints of the current code enables a subscriber to outsource internal complaints handling to a third party, that is, to receive and/or handle complaints about the code subscriber's products and services. If a code subscriber has authorized an external lawyer to receive or handle complaints about its products and services, then the lawyer must comply with the provisions that apply to complaints handling, and this includes an obligation to make a decision about a consumer's complaint within 45 calendar days under paragraph 147. Just noting separately there, of course, that time frame is going to be reduced to 30 calendar days from the 5th of October 2021, and I am aware that all subscribers have worked on that and that's implemented and will be implemented, and there will be a Annabelle, you can confirm that there will be a change to the code to affect that. The lawyer must notify the code subscriber of complaints made to them under paragraph 159B, and if the lawyer breaches Part 11, then the code subscriber will be in breach of the 2020 code. It's also not unusual for a code subscriber to outsource debt collection activities to external lawyers. If the code subscriber has engaged an external lawyer to pursue recovery of money owed by a consumer, the lawyer must comply with the applicable obligations in Part 10 financial hardship of the code. Some of the obligations that apply to an external lawyer are to understand those hardship requirements in the code and receive training to help identify whether a consumer might need financial hardship support, identify the code subscriber in correspondence with the consumer. If no further information is required, to assess a consumer's request for financial hardship support and make a decision within 21 calendar days, and to work with a consumer entitled to financial hardship support to implement an appropriate arrangement. And of course, and this was in the previous code as well, to comply with the debt collection guideline for collectors and creditors as published by the ACCC and ASIC. Part 10 applies to a code subscriber and those it engages to collect money owed to it by either a customer of the code subscriber, but not if the financial hardship relates to the payment of insurance premiums, or it also applies to a person, typically uninsured, who the code subscriber believes has caused damage or loss to the insured or a third-party beneficiary. So a little bit of history, a little bit of insight. It's still very early for this. I think I'm hoping that we can have a similar discussion in, say, another half year or a year's time, because I think that will provide far richer insights from my part. But happy to just throw back to Shannon at this stage for the next part of our presentation.
Well, thank you, and thank you to our speakers today. I've got a couple of questions that have come through, and the first one I think I'll throw out to the floor. What will the code achieve that the raft of reg change won't? So, for example, unfair contract terms, etc. Other than the customers experiencing vulnerability, has the code become redundant?
I might go first with that one. Shannon. Thank you very much for the question. It's a very good question, isn't it? It's something I think we're trying to work through with the Enforceable Code legislation as well. The advantage of grey letter law is that it's very, very flexible. So the code has the ability to respond almost immediately, if need be, to changing community needs. We actually did that back in 2011 when the floods came through Brisbane, and we found some issues across the sector that we hadn't realised that were affecting consumers at the time. So we actually did that, a nice cycle change to the code as a result. So I agree that the legislative framework is changing and it's tightening in some ways, but the code itself continues to be a living document that responds as required. I think everybody on this call will know that it can take an awfully long time for law to be changed and updated. I think, you know, Paul and I still have the scars of 7 years of Insurance Contracts Act being discussed a few years back now. That took a very long time. So to me, that's the real advantage of it. Laws may come later that then reflect what the code does or says, you know, to enhance that sort of statutory protection, but code is a leader in that area. The other thing I personally think is a really beneficial part of the code is that it's really, I'm not saying that legislators don't do this or Treasury doesn't do this, but it really is an outcome of enormous amounts of stakeholder engagement. And people are incredibly generous. They give us a lot of time and a lot of their own knowledge and IP to help the sector understand what needs to change and what needs to be done. Including the Code Governance Committee, obviously, as part of that, of their role, and they also do work. They do motion inquiries that look at areas of potential concern and help the industry, you know, understand what's going on and if they indeed need to change the code, or through some other mechanism. And obviously work very closely with our colleagues at Legal Aid and Financial Rights and CALC. So that, to me, is why it isn't redundant. It actually is it's almost like a lead reflection of consumer needs rather than a lag reflection, which to me is what, you know, black letter law ostensibly does.
I would echo that, Annabelle. I don't think it can be underestimated the collaborative effect that leads to the code from everybody involved who assists consumers, both from the industry side, regulators, AFCA, consumer lawyers and financial counsellors. It comes about because everybody's able to put their experience and their best knowledge into the ultimate goal, which is a goal we all share of what makes this easier for a consumer who's in a bad spot. And that is such a powerful tool that industry is able to say, we're able to work with everybody in this space to get something that reflects the help that consumers currently need. And that doesn't necessarily have to be legislative help. It can be help that involves just simply making a claims process easier by putting a phone number in the right spot, which is something that sounds the silly outcome of the code. But the difference it makes to somebody being able to look at a document and say, okay, I need to call this place X next, is actually takes a whole load of stress off people. So it's even those little things that the code brings about that are just important as those big picture legislative things we're talking about. And that also contributes to a view that the public has of, well, they give a damn about us. They're trying to help us. And everybody already has that intention, but having a public reflection of that is really important too.
Thanks, Paul and Annabelle. I echo both your insights. I also think that particularly that point on that stakeholder engagement and hearing the voices and the needs of all the various parties, and one of those is, of course, also the inclusion not just of the vulnerability provisions, but also the Part 15 of the code on investigations, and setting a standard, and in a way setting a standard that benefits consumers, but also adds value to the processes for industry. It's a bit of a race to the top in that respect. It also reacts much faster than the law, and the ultimate aim of a code as well, or one of the main aims of the code, is not just to restate the law, but to provide additional obligations or promises, let's call them promises, that are then being kept to the benefit of both consumers and for industry.
Thank you, everyone. Now, the second question that's come through, it's directed to Paul. So on Drew's report on family violence policies on the insurer's websites, incorporating Drew's findings into a family violence external policy will result in a lengthy document. How does this correlate with your comment about succinct information for consumers?
Okay, and that's a reasonable question to ask. I think there is always a balance to be struck between giving people information they need in a succinct way and doing a document that goes on for 90 pages that's not understandable. And I think even incorporating a lot of the feedback Drew put in his report, you can still write a family violence policy that doesn't go for longer than, say, a dozen pages, just as an example. But write it in such a way that anybody off the street can pick it up and go, okay, this is how an insurer is going to help me.
Thanks, Paul. I've got another question here, and I think I'll throw it out to the floor. How do you think the code has changed the role of the claims examiner? So, in relation to customer vulnerability, etc. I'd like to hear your opinion on that.
Sorry, Shannon, I don't use the term claims examiner. Are we talking about claims staff generally, or loss adjusters,
staff,
or?
Yes.
Oh, okay.
Yeah, yes.
Thank you. Look, I can only speak from the experience that I've had in terms of the actual implementation side of the code of practice. But I am very aware that from Suncorp's perspective, at least, we built a very, very robust process for our staff, which includes a lot of training, actually, and that's ongoing. And we put in support services so they can access. We use Uniting Kildonan to help customers who are in really dire need and need extra support for whatever reason it may be. And the feedback that we have had from our people has been tremendous, because suddenly they feel empowered that they can actually do something about something they're seeing. Whereas before it was probably a bit grey, and yes, the organisation, of course, would want to do the right thing, not saying that, but there was no sort of obvious way to access support for customers. So I think from my observations, having implemented the code into Suncorp, is that it's been very empowering, and we're actually just doing a process at the moment where we're assessing the impact of it on our business in terms of our staff. And you can see the feedbacks come back through fantastically. I know what to do now. I can help that customer and family violence. I do know there are specialists who can work with me on this. I'm beginning to understand the complexity as well, because some of the stuff is really complicated. And I feel that I have the ability to actually make the right decisions and be fair and support the consumer, etc. Because the reality is, I personally believe that, the vast majority of our claim staff, if not all, are incredibly empathetic and compassionate people. You wouldn't do that job if you weren't, because we all know it can be extremely taxing, and you hear some terrible stories from consumers, and it doesn't necessarily have to be a big house fire that leads to that story either. And so it really has supported, I guess, the cultural perspective of our industry with the claims staff that work within it. Thank you.
Thanks, Annabelle. And it's great to hear that there's that feedback loop. My sort of contribution to this answer is really that it's an iterative process as well. So the whole framework of vulnerability and providing systems and processes, etc., and training. I've been aware through various forums, etc., that the industry has been working on this for several years now, and one of the messages that has come through and that's recognised by me as well is the fact that this is an iterative process and an ongoing feedback loop process. So vulnerability can take many forms, and as you've noted, Annabelle, can be complex. Sometimes, but not sometimes, I think more often than not, there are multiple vulnerabilities that can occur at the same time. Financial, work, psychological, all sorts of factors, which makes it difficult and complex. And then also great to hear as well, which is something that I knew was happening in any event, but is that it's the evaluation of the impact of the training and systems that are in place to get that feedback, but also to see where improvements can be made. And I think that's really important. And it's something to remember that there isn't one set process to deal with vulnerability. It just keeps on changing, and it's a learning experience. So that not being in the claims sphere myself, obviously, but just knowing how this works in other codes and other industries as well. Banking is very similar. It's this loop. It's this ongoing review, critical review. What can we do? Listening actually to the people who are vulnerable about what they need and what the questions are and how they need to be asked and addressed. And Paul, I might throw it to you if that's okay, because you probably have more insight from that view.
Yeah, I think where I'd start with this is, I'd say at the beginning, it's important to give your claim staff a break on this sort of stuff. And the reason I'd say that is I've been doing this from the other side for 13 years now, and I'll still get it wrong. You will still encounter people who are extremely vulnerable, who for whatever reason don't respond to you or the approach you use, and basically lose it at you. And that's not a sign necessarily that the claim staff has done anything wrong. It's a sign that that person is in such a horrible space that dealing with another person is not something they're up for just yet. And so I would encourage everybody to be aware that it doesn't matter how well you do this, sometimes it won't work. And that's actually okay, because nobody's perfect at this, and I'm still learning and getting better at dealing with particular groups 13 years later, and I suspect I'll still be learning in another 13 years' time, because vulnerability is so wide. You will never be completely on top of how best to approach people and how to do it. And even if you do get to that nirvana, sometimes people still won't respond. So it's all about not only giving your claim staff a break when something goes wrong, it's also about recognizing that sometimes the consumer isn't in a space to deal with what you want them to deal with. And it's okay to go back to them in a couple of weeks or 3 weeks or 4 weeks or ask them when is a good time and then revisit it then. Failing at the first hurdle or the first interaction doesn't mean the process is broken.
Thank you. And we've got one final question, which again, I'll open up to the panel. So an audience member has said, part 3 of the code, to my mind, is one of the most powerful parts of the code. Interested in the panel's view on part 3, so our obligations to customers.
I'm happy to start that one. being. I agree it's really powerful because I think you can view it not only as almost providing the Bible as to how you assist customers. In one sense, you can also view it as informing the other obligations in the code as to how you might go about doing some of them and providing almost that overlay of the other obligations to the code. And I think that sort of commitment so early on in the code is really important to people like me, because we see it as a sign of the serious commitment that the industry is making to how they treat their customers.
Yes, my view is also that these are actually this overarching obligation is one that in the previous codes it sat within several different divisions or parts of the 2014 code, and it's been pulled out as a significant part on its own. And I think what it reflects is, and this is a reflection not just on this code but on all codes, that it really codifies the fairness aspect, that basically sits and works through all the obligations within a code of practice, including this code. So it colours and informs all the other obligations. Annabelle, what's?
Thank you. This is a very interesting section, actually. We were discussing it at our quarterly meeting the other day, weren't we, Rene? So the history of it was we got feedback when we were reviewing the code that what had happened prior, as Rene's rightly said, is that those concepts were sort of at the front of each sort of section of the code itself. And I think the Code Governance Committee and others gave feedback they'd like an overarching statement at the front. For those that don't know, this is the honest, efficient, fair, transparent and timely section. That's what we'll be. Section 23, I think it is, and then the section 24 explains how that works. Yes, it's very powerful. It's a reflection, obviously, of law more generally, but it's really saying this is how the industry meets these obligations or these concepts. I personally would read it in conjunction with principles at the beginning. I hope you don't get any background noise, someone's just come in. So yes, that's how but I do agree, it's very powerful concept, and you know, we're all learning about what that means and how it's going to work into the future as well. So it's a bit like the vulnerability piece. This is a moving and shifting thing because it's very much really based on consumer community expectations and needs and standards. Yes, it was very deliberately done to be set up that way.
Thank you. Thanks, panelists. So that's it for questions today, and I know it's 5 o'clock. So I would like to thank our panelists and audience today for their participation in the session. I took some valuable insights and we had some really great questions. So I thank everyone for their participation. Before I conclude, please check the AELA website for all upcoming webinars and events. And another reminder that this webinar has been recorded and will be emailed to the audience tomorrow for a period of 2 business days. A recording of this webinar will then be available for paid members of AELA to view via the library after the 1-month embargo period. So once again, thanks everyone for joining, and enjoy your evening. Thank you.
Thanks, everyone.
Thank you. Thanks, everyone. Bye-bye.